You're alive.
Okay, good morning. This is Senate Natural Resources and Energy, and it is, what is it? It is February 12th. It's a Thursday, and we are starting the morning hearing from Judge Snre about S224. And just to give a quick preview, we have a new draft of 223. We have a joint hearing together with transportation, which I'm pretty excited about. We're gonna go back to 224, and then we have some 101 level information about Act 250 coming from LFJC. So that's sort of the rundown of the day. Yeah, we're gonna start with Judge Snre. Welcome.
Good morning, thank you. Tom Snre, Chief Superior Judge. I have the version 4.2 from 2/11/26 at 7:40 a.m.
Yes, excellent.
Thank you for your
Yeah.
nice work. So I will touch base on, I looked at section 2 is the one section, as well as if we get to section 2, it's on wake boats. And so a lot of language is added. The statute goes through pages 2, 3, it talks about what prohibitions are. When you get to page 4, on lines 6 through 9, what it says is all provisions of section 1454, which is another section that the legislature has enacted dealing with aquatic nuisance inspections and things. It says they also apply here under this section, which is the new section. So the question I had was why, and I leave the ledge counsel, but I don't know why that has to be there, because 1454 applies to vessels.
Yeah.
So a wake boat is by definition a vessel, because it is something that can be transported, can go over the water, and it's not one of the exceptions under the definition section. And so it was unclear to me why you needed to reiterate that here, because it does add a potential bit of confusion as far as penalties, whether you want a penalty under this section or the other section, but I'll get to the penalty section in a minute, but I just don't know that that's absolutely necessary. And I have to smile, because as I was reading it, I went, well, isn't it wake? And I read it in order. So I didn't look at the definitions first. I read it and I went, well, isn't a wake boat a vessel? I've had a US Coast Guard master 50-ton master captain's license for a while.
Oh my God.
And I'm going,
Wow.
well, the federal definition is this is a vessel, and it would fit. So your definition is the same.
Okay.
That works.
We have a question here, yes.
So in 1454 Judge zoning, does 1454 require a vessel to drain their ballast tanks or any other tanks or bilges when they leave the water?
It has, I don't have that, all of that down. It has other restrictions. I actually sat there last night looking to see if it was the same. It has some different restrictions, but you don't lose anything. If you took that out,
Yeah.
those restrictions still apply. And for wake boats, the new restrictions that you're imposing will apply to wake boats also. So it's layered.
So where does it say then, if we didn't include D, where does it say that a wake boat shall drain their ballast tanks?
If it's not in 1454,
Right, then
yeah,
it's fine.
it's already there. If it's not in 1454, this doesn't change it. It's in, I believe it's in 1454, because this reference says all provisions of section 14 regarding aquatic nuisance species and wake boat users shall drain immediately before. So what you may want to do is you take the first clause, all provisions of section 1454 of this title regarding aquatic nuisance species inspection apply to wake boats, and if you cross that out, you still have 1454.
Yeah.
It's all still there. And then if you want to make it clear what you're asking about, just start with wake boat users shall drain. And so you're putting it in here.
Actually, so on page 5, the top, it says section 4. That is, I believe that is 1454.
It is, 1454.
Oh, yeah, it's right there.
Yep, and then that's where we've got the immediately before or immediately after leaving the water,
I think we could strike,
D.
yeah.
And so that was my question, was when you say that, this section may not need to be, or you're talking about all of D?
Well, that's correct, as long as you're comfortable that the drainage part is, I see it on page 5. As long as you're comfortable that you don't need to add anything else. The provision is already applied by operation of law, because a wakeboat is a vessel.
Okay.
In the language that wakeboat users, they refer to these tanks as ballast tanks, they don't refer to them as something else or.
That's a good question, I
Yes.
don't know.
I mean, I think that makes sense,
Sure,
or no, yeah.
Because on page 7 is the definition of vessel. Vessel means every description of watercraft other than a seaplane on the water or a racing shell or rolling scull occupied exclusively by individuals 12 inches under or capable of being used or capable of being used as a means of transportation. And so really it's every description of watercraft used or capable of being used as a means of transportation on water, then it has exceptions.
And then 20.
And then 20 is a big part. It's a
Yeah.
motorboat. It has, all it does is just define it as having ballast. It's a subset of vessel.
Do we need to? Okay, yeah, I think that's fine. I think we can get it.
yeah,
Yeah.
that makes sense.
Well, I wonder though if we could say on 20, wakeboat means a motorboat, have vessel in the definition of wakeboat.
You don't have it for any other types of boat. It is clear enough that it is because you say it's a watercraft or motorboat. Wakeboat means a boat. It's just. It's a boat. It's a vessel.
Okay.
Common sense interpretation.
Yeah.
That's,
If you wanted something indeed to really drive it home, you can say. A wakeboat is a vessel, but it is a vessel.
yeah, but I mean. Just because we put it in statute doesn't mean. A wakeboat, I mean, that's at the agency level to make sure that in all their literature it's in there. It's a good number line 7, because. Page 5, it's what actually specifically says.
Oh, it does say ballast tanks.
As we sit here, is it a watercraft? Is it capable of being used as a transportation on water? Well, yeah, that's what it's for. So. And the other part ties into the 1454. If you look under subsection E on page 4, lines 10 through 16. It says that pursuant to 1102, it talks about the violations and where they can be brought. They can either be brought in the judicial bureau or in the environmental division. The question that comes up is, what's the penalty? If, when they're brought, and let me hand out as I can, I thought it might be helpful. The penalty structure is under, what happens is it refers you back to 23 VSA 3317 subsection B, under the code there. That up. And this is that section.
Great, that's okay.
Everybody have one? I bet you.
Okay, thank you.
And so if you look, the highlighted is something, and underline language I added. It says that the person who violates a requirement under 10 VSA 1454. Because that's the section for aquatic nuisance, so it's very, shall be subject to enforcement under 8007 or 8008 or a fine under this chapter. Then it has the penalty, not more than $1,000 for each violation. And so you're trying to link, it looks like, this is a policy decision, the penalties for 1424B with those for 1454. If you add it under 23 VSA 3317B, as I show there, that makes it clear that the penalties under this new statute are the same.
So wait, I want to make sure I'm understanding. Are you suggesting that on page 4, line 12, we change?
No,
Oh, okay,
no, I'm saying on, you need to add a section somewhere.
okay,
I think that would make it clear that the 1424B violations that you're establishing by law
mhm,
and that you're providing under subsection
Oh, I
E for the mechanism. to put somewhere to say, okay, here's where the penalty goes back to, and that, because it's consistent with how you have 1454.
So you're suggesting we could theoretically place D. For language.
Replace,
You're saying add this clause somewhere.
yeah, I think it has to, well, I mean, a new section of the bill.
Yeah.
Yeah,
Okay.
for everyone, I think, but I think you have to bring it in to Title 23, under 3317, because that's also the place that allows waiver penalties and things like that to be established. And again, it brings it right in line with what you do with 1454. And I see, and that would also be consistent because section 3 at the bottom of page 4 that is added, the language is adding 1424 to judicial bureau. And so that would align everything.
And just to be clear, it aligns it.
1454. Okay. And those are my comments.
Okay.
Wasn't
Right,
there, sorry, wasn't there another section of the bill that related to the courts?
It was not in this draft.
It's not in this draft. Okay, got to.
I did not find it.
Okay.
Okay,
I did several word searches too to make sure, because I remember the old language.
Yeah, there were two sections. Can I just
yes.
ask if Mike has questions since it's the next time, just come in?
Well, so we can relate to you, because there were basically two suggestions that I heard from Judge Zoning. And so just to sum them up, I've understood them. On page 4, section D, the thought is that D is perhaps unnecessary, that it may already be covered, and that perhaps adding a section may be confusing. Anything that you would want to add to that?
Weight boat is a vessel already. And so there's no necessity to add something saying that the provisions that apply to vessels also apply to weight boats.
That's fair. It's fair. It's a bit of bootstrapping, but it's fair.
Okay, and then the other one is adding a reference to 1424B, which is this new section, to 23 BSA 1317B about penalties.
Yeah, that I heard the judge
You got it.
say that, and
Okay.
it totally makes sense. I totally understand this.
Okay, I think that's excellent.
Thank you.
Okay, thank you very much.
Great day.
Yes, you as well.
Yeah. What, do you mind if I go?
No, it's all good. Cool. All right, so,
These are cookies from Terry.
Oh my God.
550.
so, and so just to be clear, Mr. O'Grady, we, you know, for some future draft, we can include those.
Sure.
I don't know when that will be, but, for the next iteration.
I am working on the draft. I think the only thing from yesterday that I need to do is the education and outreach component.
Yeah. Well, and for what it's worth, I'm feeling yet unsettled about the aquatic, or about the use of space, the aquatic invasive boat stations, decon station locations in the prioritized list, and how we resolve that. I'm just putting a pin in that. I would love some more discussion.
I did send you an email this morning.
Yes.
So.
I have, well, I saw that you said it, I haven't read it yet,
Okay.
so thank you. But if you would go ahead and come on up, because we're gonna transition to a new draft of 223. And for this, I'm gonna turn it over to Senator Bongartz to give a little introduction.
So if you recall, 223 is the study, so it's certainly been work, it's the study. And it was a little bit rough at the beginning when we got it in under the deadline, and began to realize it was a little. Advocates worked on it with me and was a little cluttered, wasn't the best, tightest drafting and quite did a little more work. And what this really does is just, there was also a sense that we were asking that study committee to do so much, nothing would get accomplished in the amount of time. So we're trying to bring it down, get clarity about what it is we're looking to do. And I think we went from 7 bullet points of things we're supposed to consider to 5, and just basically just tightening up. It's the usual second draft, tightening up. So, but.
Go ahead.
So, this is Mike Gray with the State Council. As Senator Von just noted, this is a redraft of S2 23 as it was introduced. It does refine the bill as introduced, but there still is the focus, the 3 major focuses of this study group is to look at how water quality is analyzed and implemented, the water quality requirements are analyzed and implemented, how lakes are classified under the water classification system, and whether and how the state is implementing and complying with federal anti-degradation implementation requirements. And so you will see that's really the name of this group, the water quality lake classification and the anti-degradation studies. It's created to evaluate the existing statutory and regulatory frameworks, policies, etc., for water quality and classification of waters of the state. On page 1, 13 to 17, it recommends to you, the General Assembly, whether the current regulatory framework of waters of the state is adequate, whether there are changes to strengthen protection, provide certainty, and support other public interests. And state there would be 11 members, 2 from the House, 2 from the Senate, the Secretary and Natural Resources are her designee. A DEC scientist, water quality scientist, or technical staff member appointed by the Secretary. 2 persons representing businesses or industry that basically interact with water quality permitting, such as anti-degradation or classification. One's going to be appointed by the Speaker, one by the Committee on Committees. 2 persons representing nonprofit environmental advocacy groups, one by the Speaker, one by Committee on Committees. And 1 person representing the Federation of Lakes and Ponds, appointed by the governor. So what is this group going to do? What are their powers? On page 2, line 17, they develop an inventory of the waters of the state with their existing classification system, including those waters that qualify right now for a higher quality classification, but haven't been reclassified. I believe you heard testimony about that. There's a substantial number of those waters that could be reclassified for higher quality and then better management. Page 3, line 1, they've also.
Sorry, clarifying. Where does it actually say that? This is this both the clause, the second clause.
Yes, where it meets or exceeds the minimum criteria for reclassification for such waters.
Okay.
Those candidate high quality waters.
Candidate, but not moved on. Sorry. Okay.
Page 3, assess the state's obligation under the Clean Water Act to adopt an anti-degradation rule and implement it, and including an evaluation of the state and federal requirements, and identification of any legal, administrative, policy, or practical barriers. Page 3, line 7, they will identify and evaluate the statutory regulatory framework, rules, and policies for governing Class A waters, including whether modifications are needed to facilitate reclassification. So is there something that's prohibiting or barrier to reclassification now? Maybe it's rulemaking because you have to reclassify through rulemaking. Maybe it'd be easier if you didn't have to go through rulemaking to reclassify. Page 3, line 12, they'll also evaluate the existing water classification framework, and whether there should be a separate classification system for lakes and ponds. You discussed this previously. There are other states that have different classifications for lakes and ponds. Sometimes they're based on development, sometimes they're based on the environmental status of the lake. And so maybe that should be something separate from the general classification, water quality classification for all waters in the state. And that evaluation shall include an assessment of current and potential threats to water quality of lakes and ponds. Consider whether the existing classification systems protect against such threats. Page 3, line 18, recommend legislative amendments and identify any rules, policy, or procedures that may require revision to implement the study group's recommendation. The group will have the administrative, technical, and legal assistance of A&R and the legal and drafting assistance of the Ledge Council, which is probably needs. Page 4, line 4, there's a report back December 30th, 2026, and it includes its findings. All of those findings are duties that it is required to do under subsection C. They call the first meeting on the report August 1st. The chair is chosen from the 4 legislators. They cease to exist on February 15, 2027. You and the other members that receive compensation get compensation for 8 meetings. And then the effective date is passive. So have to note, because there's compensation, we'll go to appropriates.
Okay. Thank you. It's clear enough to me. I'm good about it. Any questions at this point?
My notes from that, but I wasn't sure.
So somebody explained to me. Why we need this group, and we shouldn't just trust A&R to do its work.
That's a good question. I feel like I can take a crack at it, but I defer to some other people here.
So these are just facts. So here are some of the facts. The Clean Water Act requires an anti-degradation implementation policy, which the state has in the water quality standards, water quality rules. But there's also supposed to be a policy that implement that. And the General Assembly in legislation have required the agency to adopt that policy by rule for about 20 years now.
Okay.
And it hasn't been adopted by. So what are the requirements for that? Is the state complying with the Federal Clean Water Act requirements for anti-degradation? That's part of this study. The second thing is those classifications of waters. It's like there are waters that qualify for higher classification. And anti-degradation is part of that, because under the Federal Clean Water Act, you are not supposed to manage a water so that it degrades. So if a water is already meeting that standard, it should be reclassified so people know that it has to be managed not to be degraded. But those waters are not being reclassified. Now, technically, they can't be managed to degrade them anyway, because that's both in state rule and in federal law, but that's not being done. Why is that not being done? There are numerous waters that qualify for reclassification. What's preventing that?
Well, that's a good question. I mean, I don't know. I mean, 20 years, we're talking about A&R under a multitude of different.
It's there's
not a Republican Democrat.
Exactly, yes.
And then last, it really is to an extent about whether lakes should be different from other waters. Because right now it's just a uniform water quality analysis, and should it be different? Should you manage lakes and ponds? And that's effectively why.
Thank you.
It's a good question. Right. Thank you for that. Any other thoughts, questions, concerns at this point? Okay. Super. All right. Well,
I think it's much better.
yes. And we're gonna hear from some folks about this tomorrow, so we'll be hearing more about that soon. All right, so our next engagement is at 10:15, so we've got some time, which is great. And it's a joint hearing with transportation, and we're gonna be in room 10. So I think we'll just meet there at 10:15. Oh, and actually, before we go offline, just to give that a little context. Thank you, I'm sorry. I'm gonna try to be better about giving context for previews. I feel like I'm not a tweak. Okay. So yesterday we saw a new draft of S 325, tweaks to Act 181. One of the things that has happened since Act 181 is there's been some impacts to transportation. And so we're going to be headed to this joint hearing to hear from the Agency of Transportation about what some of those impacts have been. And again, my filter for all of this is, are these what kind of course corrections do we need to get to the vision of what we intended with Act 181? Are these technical corrections? Are these relatively straightforward fixes? That's the filter that I want to have for anything that we end up adding to Act 181. But I want to at least give AOT the opportunity to make their case. Let's hear what the issues have been. Transportation was really not dealt with very particular. Yeah, exactly. Not in a robust way in Act 181. And if there are things that need to be adjusted or corrected, I'm going to be open to that. So we'll hear what they have to say. That's the context for this upcoming hearing. And then again, just for context for the rest of the morning. So we did have a request from Chris Bradley from the Vermont Federation of Sportsmen's Clubs to speak on S2224. So we're going to do that, and then we'll hear from Ella Tchaikovsky about Act 250.